I'd like to welcome our guest for this hour. Joining me in the studio, we have trial attorney Miguel Custodio, and also joining us, trial attorney Jean Rossi. Thank you, Miguel, for being here in person with me. Always appreciate you. Let me start with you, please. Tell me your thoughts, as this jury has now been out for 23 minutes, and what you think it might be like or where this might go.
I think, first off, hats off to the closing arguments by both sides. They were masterful arguments. I thought Jackson really played into the passion and the corruption theme, whereas Brennan was just about data and just facts. He was very methodical, and I thought that was great. I personally think that the jury here is going to be very confused about where to go. I really think that there's a lot of doubts that have come up here as to the investigation of the police, and I think that really just doesn't sit well with jurors.
Yeah, I agree with you. This jury has so much on their plate. Jean Rossi, of course, great to have you. But Jean, tell me, what do you think about where this jury might be and how you think it all shook out with each side, really excellent attorneys on both sides?
My view is this, based on winning some and losing some. When you have two powerful closing arguments in a case that focuses on data, and there's no eyewitnesses, and there's a lot of conflicting testimony, I think that inures to the defendant's benefit. That's point one. Number two, if we get a verdict today, it's going to be not guilty. But we're not going to get a verdict today. The jury is exhausted. They want to go home. There was a mention of the stacks of notes. They're going to deliberate probably till 5 p.m. today and come back Monday. I predict a verdict by late Tuesday or Wednesday. And if I had to bet money, if I was in Vegas, I think the odds are in favor of her getting, at best, an acquittal, and at worst, a hung jury. And here's why. It goes back to what I said a couple days ago, Judge Ashley, when you have a battle of experts, and you know, the prosecutor kind of led with his chin in the sense this is about data. Well, if you have a battle of experts and one side says, oh, there was this hit and then the car was moving this way and that way at the right time, and then you have another couple of experts that said, no, this didn't happen, a jury is going to be torn with that. And I think that the defense looked at the first trial and pruned their case in a brilliant way. And we talked about this a couple of days ago, where they got rid of some witnesses in the house, so they got rid of all that stuff, and now they're just focusing on data. So when the prosecutor said this is a case about data, it could easily be said that defense is about data. So that's why I think it's leaning in my gut, my Malcolm Gladwell gut, is that she has either a hung jury or an acquittal.
Wow. All right. So, Miguel, weigh in on that. And I have to say this, as Matt said, 3 to 4 days last time when there was a hung jury, Jean. And what must it be like? 2 questions for you. First of all, where do you think they might land? But second of all, what must it be like for any defendant, much less a Karen Read, that the entire nation, likely world, is following, watching, and either supporting or not, to have to wait while this jury deliberates?
I think there's going to be a hung jury again, and I just don't know if the prosecution really convinced the jury here in this case. I mean, there's just too many little holes here that I think creates a reasonable doubt. Karen Read right now is probably very confident. I think she's very confident in what's going on. Obviously, she's nervous. She's very, scared of what's going on, right? Because there's always a consequence that she can go to prison. But I really think that she's in a really good position right now.
And I'll tell you, watching her today, no comment when they left. Well, this time she didn't have anything to say. I want to listen together, gentlemen, and then circle back to you, Jean, what the judge had to say about the jury instructions, because we know the defense was concerned about them, argued for some changes because they wanted to be clear what was in those. Let's listen to that together, please.
And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear.
All right, let me ask you, Jean, because I believe that you may know this judge, and I think to me what it meant was, listen, it was clear before, but I'll look at it again because we want to make sure the jury knows exactly what the law provides for that they have to follow.
Absolutely. A full and fair disclosure. I'm a big fan of the judge. We teach at Harvard trial advocacy law, and I was the courtroom deputy in the mock trial, so I was the one standing in front of her, sitting in front of her, swearing in the witnesses at the mock trial. So I like her a lot. But this is the nerd in me. I love jury conferences. I can't tell you how many trials I've had where I've gained a little advantage or lost an advantage of significance during the discussion about what you're going to read to the jury. And I can't tell you how important jury instructions are, because whether you're defense attorney or the prosecutor, you're going to hold them up or refer to them, and they could help decide your case and create either a guilty, hung jury or an acquittal.
I absolutely agree with you because, Miguel, the jury instructions, I mean, that's where the rubber meets the road. They go back there, they decide which facts they agree on or don't agree on, and then they have to look at those to say, and this is the law we have to apply. If there's any bad wording, wrong wording, confusing wording, it can throw a jury completely.
Absolutely, because we got to remember, jurors are lay people, right? So they are not exposed to this type of language on a regular basis. And so every single word matters that they're reading in terms of the jury instructions. So it's very important that it's clear, crystal clear.
Yeah, you're right. That's a great point. It's lay people that are having to make this decision and follow those instructions. Well, good news. We get to listen to those jury instructions together because we do need to hear exactly what this jury will need to consider while they're deliberating. Again, 30 minutes. We have been bringing you all of the closing arguments, which is why we're just now getting to the jury instructions, and those are up next. Stay tuned. Still with us, Miguel Custodio and Jean Rossi. Miguel, you and I were talking about jury instructions, including some of the normal things. One of them is jurors use your common sense. Don't leave that at the door. And we were talking about the prosecution's evidence that that car that she was driving accelerated and then backed up 24 miles an hour. What are your thoughts?
Well, I've had cases where I'm representing a pedestrian in civil cases against a vehicle that hit them. And for a vehicle to strike, in this case, 6,000-pound car to strike him, he was stationary, strike him at 24 miles per hour, the body will leave a lot more marks than what you see that left with him. So you would see bruises, you would see a lot of bruises, a lot of purple, and all he had was a scratch on his eyelid and on his nose and some scratches on his arm that, hey, most likely can be a dog bite. So I thought it was common sense will, I think, win here, and that's why I think that the defense, will get either a hung jury or acquittal.
And that common sense piece, I have to say this, though, Jean, in the first trial, the defense obviously put up a lot more evidence about that conspiracy theory and cover-up, and more people from inside the home testified for the Commonwealth, and the defense was able to use that to really say, there's something shady going on there, and it included a cover-up and hurting John O'Keefe. That wasn't present this time. So how do you think common sense might come into play?
I think common sense is going to be one of their last witnesses for the defense, that crash guy who reconstructed and said it's not consistent with somebody being hit. But I want to focus on the jury instruction that's going to decide this case, in my humble view.
What is it? Tell us.
It's the money jury instruction, and Judge Cannone, I call her Cannone because I'm from Connecticut, but Judge Cannone and I talked about this instruction when we were teaching together. You have to find by a moral certainty that she is guilty. In federal court in the Eastern District of Virginia, which is less than a half a mile from my house, that instruction would never be given. In Massachusetts, It's a beautiful instruction for the defense. A moral certainty, and it's what I said a couple of days ago. They have to go home, look at a mirror, and say, to a moral certainty, she's a murderer. I don't think you're going to get 12 jurors to say that she's a murderer to a moral certainty, based on the evidence in the last few weeks. No way. I think at worst, she's got a hung jury. At best, of course, it's an acquittal.
Gene Rossi, it's like you read my mind, because I had written down to a reasonable and moral certainty because it stood out to me as that's not always in jury instructions. So I'm so glad you've addressed that and what you see as a win for the defense. Let's listen together, because I do want to listen to a little bit of closing argument by the Commonwealth and what they said about Reed being drunk and how that might affect it. Let's listen.
She made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk, she hit him, and she left him to die.
What do you think, Miguel? Intent or no intent? Knowing they're saying she was drunk, well, did she really mean to do this?
If you're drunk, and we know that the stats here show that she was drunk 2 to 3 times over the legal limit, I just don't see how you get that intent. I really just don't. It seems very hard for me. I don't think that they met that burden, and it's going to be really hard.
All right, the intent. Do you think there's any opportunity for that to be a conviction, Gene?
Oh, no. I mean, I could lose my bar license betting it, but it gets to alcohol. Alcohol, if you have a specific intent crime, alcohol brings it down, it negates specific intent. That's number one. And number two, obviously there's some jurors that are familiar with intoxication. And they're going to put themselves in her shoes in that car. And if the prosecutor's theory is correct, that she backed up and ran him over, the prosecutor's kind of arguing against himself because she's drunk. Well, how can you develop this specific intent to murder him and make that choice? I'm going to leave him for dead. Those are two inconsistent positions in my view. Negligent homicide may be an argument they could make, but not the charges that they have at the top of the list.
And that's why I think there are legal analysts who've said they think that the Commonwealth overcharged her because of exactly what you just described. I'm not saying they did or didn't. I'm just saying a lot of people feel that way. All right, stay tuned. We'll get you back inside the courtroom for more of the jury instructions up next. On top of the hour, of course, thank you to Miguel Custodio and Gene Rossi. The verdict clock, you can see it there, 1 hour, 11 minutes. That's how long the jury's been deliberating.